All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I call your name, please say present or here. Raise your hand so that I can acknowledge that you're here. Failure for me to hear or see you may result in me marking down something inaccurate on the docket, such as issue a warrant for this person. Okay, so it's very important that I see you and hear you. Michelle Daly. Here. John William Legendary. How do you pronounce that? How do you say that, sir? Lejean. I'm sorry. Thank you, Mr. Lejean. Sandra Miller. Marquiston Williams. Marquiston. Brittany Boyd. Brittany Liddell Boyd. Lauren Foley. John Mosley. Damon Gutierrez. Rebecca Hunter. Rebecca Ann Hunter. I understand Mr. Ashmore, I have a note here that says that she's going to be late, has ride issues. Do you know anything about that? She may have called Miss Abraham. I'm not sure. She did. Okay. All right. I'll just make a note. Caden Mitchell. Jesse Tashner. Ladary Ward. Cody White. Cody D. White. Xavier Rojas. Ms. Tabor. I'll just announce it. Billy Carl Fleming Jr., CR 2119. Mr. Cargill has filed a motion for continuance. The court has reviewed that. The court will grant that continuance, and the court will set this for plea before the court on April 26th at 9 a.m. Jason Mulligan. Tanner Sistrup. Okay. Philip Hollister. Thanks, sir. James Paul Johnson. Richard Sutton. Christina Ross. I have a note that Ms. Ross is appearing via Zoom. Ryan Augustine. Joshua Hand. Okay. Ralph Hanselka. Charles Howard. Dylan Osterreich. Oh, I'm sorry. Mr. Schmidt filed a waiver of arraignment that's granted in a pretrial set April 12th. Leonard Purley. Joshua Flores.
Judge is in jail in Arlington, Texas, as with asked for release.
Okay. I'll call you back up just a second. Heather Keels. Heather Lynn Keels. Any information, Mr. Stevens?
No, Judge, I have no information. She's calling us.
Keith Thomas. Kiana Walker. Robert Schultz. Aaron White. Aaron Antonio White. Mr. White.
He knows the computer I contacted you yesterday. He is in Dallas.
Dakota White. Claude Souls. Don Dodd, waiver of arraignment. It's been filed. The court approves that waiver and sets pretrial. Ms. Abraham, do you know if we had a date on that? I'll announce that date momentarily. All right, I believe that's all that's on the 9 o'clock docket. We have 10:30s and 11:30s. Is there anyone who's in the courtroom whose name I've not called? All right, counsel, if anyone's ready to go, if y'all line up over here, then I'll call you as you're ready. You may.
To forfeit the gun. Mr. Sister has to forfeit the gun and report it to Mr. Martin. I know we have done that before, but just logistically, that just be on the face of the judgment, or is there a separate attachment that we've used before? I emailed Stephanie to see if she has something, but I just didn't know if logistically the court had a preference.
Mr. Steele.
Yes, Judge. Josh Flores.
All right, CR 21-213, State versus Joshua Christopher Flores, and you said that Mr. Flores is in the Tarrant County School?
Yeah, he's already been jailed.
And do you know what for?
It's assault on a private person. He was arrested yesterday. It's a different complaint.
All right, court also notes that Mr. Flores failed to report in January and February. So the court's going to find Mr. Flores's bail to be insufficient at this time.
Yes, sir.
And we'll reset this for docket call. Are you available April 26th?
Yes.
All right, we'll reset docket call April 26th, and I will get an order sent on court's finding that bail is insufficient on a couple of issues, failure to report, and also being alleged to have committed a new offense. All right. Yeah, if you've already got it filled out, you just write it in jail. You take the yellow copy if you want, and you can leave the white copy for me.
What are we set for?
Docket call,
docket call.
April 26th.
At 9 a.m.
Yes, yes. And if he ends up in cut, whatever, then it'll be at 1:30 that day. But right now, we'll just set a time. Thanks, Bill.
Okay. Is there a new bond?
Yes, I'll need to review what the
Okay.
previous one was, and then I'll do a written order, make sure we get a copy.
Okay. Thank you, Judge.
You're welcome. Morning, Mr. White.
Good morning, Your Honor.
Claude Souls, CR 21246. All right, Mr. Souls, I believe is set for docket call.
Yes, sir. The last appearance, we notified the court. We believe there was a news video that Gatewood had. Ms. Heisel did some checking around, found that video. They provided it to me. There was a problem with formatting. We finally got a copy of it late last week, I believe Thursday. I viewed it. I need a little more time so I can have my client come to the office and talk to him about what's on that video, how it might affect our ability to resolve the case.
Any objection received?
No, Your Honor.
All right, court will reset Mr. Souls' docket call. Available April 12th or April 14th.
Yes, sir.
You have a preference, either one of those?
I don't think I do. Whichever one you got open.
All right, we'll do April 12th. Thank you, Mr. White. I just want to make sure these aren't my regular glasses. Need mine.
They have probation.
Maybe.
I don't see it.
It's considered probation.
Yeah, I just don't see it.
These are my back.
These are strictly layers.
Yeah, that's what they are.
Yeah, it'll all go back.
That's quite close to this.
So we got.
Ms. Daly. Come on up, Ms. Daly. That's fine, just roll that, that's fine. All right, this is cause number CR 14460. All right, this is a sanctions court hearing, Ms. Daly, so got notes here that you made your payments to probation, you made your payments to court collections, you got your community service done, so everything's looking pretty good. Agreed?
Thank you.
All right, so I tell you what, the probation office is recommending that we do. And they're recommending that we release you from sanctions court right now. All right, so listen, you can end up back here pretty quick. Okay, so you know what you're supposed to do. You got to do those things, make your payments to probation collections and do your community service. You have to do that every month, okay? Every month
I've got this.
through July of 2025. Okay, so you still have a long road ahead of you, but you've been walking the road. So we're gonna release you Office Sanctions Court, one less thing for you have to deal with. The fact that you're not coming here, don't let that give you this false sense of security that you don't have to do what you're supposed to do.
I got this.
All right? So keep it up. The next time I see you, I want it to be because you're either doing some kind of community service around here, or it's because it's 2025 or sooner because you've gotten everything done. Okay? All right. Keep up the good work and make sure you stay in compliance with your probation and keep talking with your probation officer. Okay?
Yes, sir. Thank
All
you.
right. Yes, sir.
Ride fell through or her car broke down, one or the other. So she started walking to court, somebody's picked her up and she should be here in 15 or 20 minutes.
Okay. I appreciate it. Yes, sir. I appreciate that. That's
Judge will take this.
yes. Oh, I thought you were just off the.
Why won't we do it on record?
Mr. Williams, can you come forward, please? Yes. Yes. All right, this is cause number CR 18386, Markiston Trevon Williams. And Mr. Williams, I've got a request by you to amend the conditions of your community supervision to extend your probation for an additional period of 3 months, which would extend your original period to June of this year. And during that period, you understand that if I approve that and we extend you for an additional 3 months, you're going to have to pay probation fees and your analysis fees. Do you understand that?
So would that add on to what I have to pay now?
It's not going to add on to what you have to pay, but it's going to extend what you have to pay because your probation was set to end in March. All right, March 21st. So here in a couple of weeks, but we're going to extend that. So that means you're still going to have probation. It's not adding on to your amount. That's going to require you to pay in April, May, and June.
All right. We spoke about my hours. I still had hours, but I completed them before I came to court today, so I need to update it. And I had like $500 to pay for the rest. So,
Is that what you owe total?
yeah.
Okay, so you still have, so have you completed all your community service? All right, and then you're just lacking 500. Do you think that you would be able to get that paid before March 21st?
300 today.
And 300 today.
After I leave here, and then I have 200 left.
You have 200 left. Would you anticipate having that paid before March 21st?
Yes, sir.
Okay. So this is what we'll do. I'm going to extend you, all right? I'm gonna give you that 3 months, all right? But if you get everything done before March 21st, just let your probation officer know, and then they can bring over an order to terminate when you'll be done. Okay, so in the off chance that you don't get that 200 paid, it's gonna give you a little bit of time, but if the quicker you get all that done, then they'll bring that paperwork over to me and they'll tell me, hey, he's done, let's terminate him. And then you won't, doesn't mean you have to go till June. We're just gonna give you that grace period during that time, okay? All right, so the court's gonna approve the extension to the community supervision conditions to allow Mr. Williams to finalize his compliance with his conditions of community supervision, and we'll order that his period be extended until June 20th, 2022, an additional 3 months. Okay, so go over here and see the officers. They'll give you a copy of that and let them know. Good, that's fine. Sandra Miller. All right, this is cause number CR 20137, State versus Sandra Fulgham Miller. And Miss Miller, same thing here. I see that you're wanting to amend your community supervision conditions for an extended period of 6 months, which would extend you from the end of your probation, which is March 29th, all the way until September 28th of this year. Do you need this additional period so that you can comply with all your conditions? What are you short on? Are you short on money or service?
Service, but it's been challenging. And then the class I have to take it 2 days. I tried to take it in November and I got real sick, so I wasn't able to. And then January, I got to May to June.
Okay.
So,
All right, so you're asking to have your probationary period extended so that you can comply and avoid having a motion to revoke file?
yes,
All right, has anyone threatened, forced, or pressured you to make you feel like you needed to extend your community supervision?
it's in the paperwork.
All right, court will approve the extension of Ms. Miller's community supervision for an additional 6 months with her new expiration date being September 28th, 2022. And the court will do this to allow her time to complete all of her conditions of community supervision. All right, Ms. Miller, come up here.
She mentioned that she
I'll tell you what, go ahead and speak with your community supervision officer about that. Then they'll bring that to my attention if there's an issue, okay? Mr. Schmidt, are you ready?
Sure.
When you'd like to call first?
Judge, I'm ready to roll, but
Ryan, Augustine? Augustine? Right, this is right back there. That's fine. This is cause number CR 21276, State versus Ryan Adam Augustine, set for docket call today.
it is ever Dr. Bell, Judge. Previously he had NTR as well. We resolved that case. We have an offer from the state on this, and we're still discussing it as for additional docket call for Mr. August.
Besides, any objection from the state on Mr. Schmidt's request for an additional docket call? Available April 12th or 14th. April 12th. All right, court will set Mr. Augustine in for an additional docket call on April 12th at 9 a.m. And Mr. Augustine, after you sign and get your notice, I don't know if I ordered you last time to go and speak with the court collection officer, but I show you're delinquent on a previous case that's about to go to warrant status.
It's just recently since the motion to file.
Okay. You'll just go down and meet with the court collections officer and give her your name and she'll tell you about a payment plan. Ralph Anselka, CR 21169, CR 21-170. Mr. Hanselka is set for docket call in each case.
That's correct, Judge. I'm going to ask for an additional docket call on Mr. Hanselka. Got some information for the DA's office that we need to sit down and discuss. Hopefully, once we discuss it, it'll lead to a resolution of these cases.
No objection.
There being no objection, the court sets Mr. Hanselka for docket call April 12th. Charles Howard, CR 21-76, CR 21-386. Mr. Howard is also set for docket call.
That's correct, Judge. We received a note from the state. I relayed that to Mr. Howard. I'm not quite ready to accept it yet. We'd ask for additional document.
This is his first docket call set
Yes, Judge.
on this.
Yes, we have no objection, Mr.
Mr. Howard, how are we coming with the delinquency on your money?
I've been paying it. I'm gonna pay some more today. I paid that
How much you gonna pay today?
50.
All right, court will set Mr. Howard for additional docket call on April 12th at 9 a.m. Leonard Purley. It's a CR 21-234, set for docket call.
Yes, Judge. The same announcement, we asked for additional docket call. I've got ongoing discussions with Mr. Woodbine. I think we can come up with a resolution.
No objection.
All right, I show that Mr. Purley is still $240 delinquent in attorney fees and bond supervision.
I'll be able to get caught up at the end of this week.
All right, court will set Mr. Purley for additional docket call April 12th. Ms. Heisel, you can see her.
got an agreement worked out today. However, we would need to confirm whether the feds are gonna pick this case up or file something because of the underlying charge of unlawful possession of firearm. Ms. Heisel has not heard from the U.S. Attorney's Office, but we need to confirm to cover ourselves and cover our backside on that issue to make sure that they're not gonna do anything after we plead this out.
Your Honor, we have no objection. Mr. Rojas has already executed waiver of jury trials on all of these. And we do have an agreement just as soon as they confirm with the feds that there's not additional charges forthcoming.
Okay. Court, are you available? Looking at April 12th, April 14th.
The 12th is fine, Your Honor.
All right. We'll set Mr. Rojas then for plea on April 12th at 9 a.m.
Thank you.
Will that be to probation or to time?
To time, Your Honor.
To time?
Yes.
All right, so let's set that then for 1:30.
1:30?
Yes, that way, and that'll be at the Justice Center.
Yes, Your Honor. Thank you.
All right, so if you just have him sign that notice, give him the yellow copy, leave the white one here, and he'll be free to go.
Yes, Your Honor. Thank you.
I'm gonna bring Mr. Merleader and Ms. Ross into the online court.
Judge, since it's set for status, what's the status?
Find out together. Good morning, Ms. Merleader.
Good morning, Your Honor. How are you?
I'm doing fine. We'll let Ms. Ross is still connecting to audio, so let's give her just a moment. All right, good morning, Ms. Ross. I'm gonna ask you to unmute your device.
Okay, can you hear me?
Yes, ma'am, I can hear you. Can you see and hear me okay? And can you see your attorney, Mr. Merleader?
No, I see you.
Okay, and so if you'll swipe left or right, you'll be able to see the other people that are in
Okay.
there, and you'll see Mr. Merleader.
All right, I got it.
Okay. All right, this is cause number CR 21-143, State versus Christina Maria Ross. And I show that we're set for status today. Mr. Merleader, can you refresh my memory on the status?
Yes, Your Honor. So Ms. Ross is currently indicted for first-degree money laundering, manufacturing, delivery of controlled substance. There are two other co-defendants in this case, Marcus Ellison and Mario Hobson. Mario Hobson is currently in the jail. I'm unsure if there's a deal for him. I see Ms. Curry over there too, and she can confirm the details as well. But Mr. Ellison, I believe, is going to be put on the docket for trial. Ms. Ross is a cooperating witness in that case against Mr. Ellison. And essentially, we're just waiting for Mr. Ellison's case to go to trial so that Ms. Ross can testify at that trial.
Any objection from the state on resetting Ms. Ross today until later time after Mr. Ellison?
Not at all, Your Honor. I do believe that Mr. Ellison is now on trial.
All right, so I'm going to set out a little bit further. Ms. Ross, you do need to maintain compliance with your pretrial release and follow
Yes,
their
sir.
instructions, okay? So today is March 8th. What I'm going to do is set you for a status on, Mr. Merleader, are you available on, I'm going to look into June because I don't expect Mr. Ellison to go to trial before that time. So I can do a status, another status with Ms. Ross, either June 2nd, 14th, or 16th.
June 2nd is fine, Your Honor.
Okay. So Ms. Ross, I'm going to set you for another status on June 2nd. And so So if you don't comply with your conditions of pretrial release, then I can bring you to court much sooner. Right now, I'm going to set you out further as a favor to you. All right, rather than bringing you in every month when I know that Mr. Ellison probably will not go to trial in the next 3 months. So I'm going to go ahead and extend this to you and give this opportunity to you. But if you don't report, you don't do what you're supposed to do, they're going to notify me, and I'm going to put you right back on the docket, and I'm going to bring you in person. Okay. So remind me, what state? Do you live out of state?
Tennessee.
Okay. And how do they have you reporting right now?
I send paperwork to Mr. Waddell.
Okay. And hang on just one moment. All right, Ms. Ross, so what I'm going to do is on June 2nd, I'm going to order that to be in person, okay? So that you can meet with your pretrial release officer in person.
Okay.
So
Okay.
that'll be roughly 90 days, okay?
Yes, sir. Thank you.
You're welcome. All right, so we'll see you on June 2nd, 2022 at 9 a.m.
Okay.
Right, so you're free to go.
Thank you.
Thank you, Your Honor.
First Leader, do you have anything else on the docket today?
No, Your Honor.
All right, thank you, sir. Good to see you.
You too, Your Honor.
Mr. White, you ready?
Thanks for me.
All right, let's see. Are you ready on Mr. Schultz or Mr.
Schultz be fine.
Schultz? Robert Schultz, CR 21310.
Weakness is set for pre-trial.
Correct.
Have the DVDs. At the first time I had been supplied with DVDs, however, it was not on the right case. That brings us to the second point. There may be a potential new case that may be going in front of the grand jury at some time. And if possible, we'd like to be able to see if we could not combine all of these cases together, but I don't know exactly what schedule would be as far as that going in front of the grand jury.
Are you telling me that there is another indicted case that's set on the docket?
It's not indicted yet, but I believe that the DA's office has told me that there is paperwork in our office.
We recently received a case that really like one of the grand jury.
Well, the best I can do is just reset it, and then if he gets indicted, then we'll take up that other case on the docket, and we'll try to synchronize it.
Okay, that sounds good.
So let's set Mr. Schultz then for additional pretrial on this case with DVD issues. I think I have April 12th is now full. Are you available on April 14th?
Yes, I speak here. Okay.
All right, we'll set Mr. Schultz in for an additional pretrial April 14th. Mr. Schultz, I show that you're delinquent on your bond supervision fees
This Friday. Yes, sir.
All right, so I need that resolved as quickly as possible.
This Friday. You betcha.
We need to see.
Address. So I didn't take up the.
Sorry, Alex. Mr. Schultz, Ms. Burns here with the probation office wants to see you. Are you ready out there, Aaron White? Yes. Aaron White, CR 21-345. All right, Mr. White, set for pre-trial today.
Yes, Your Honor. I don't believe there's any contested pretrial at this time. I did wind up giving the states some information. I would not think that they would have had enough time to be able to confirm anything on it, but I won't speak for the state.
All right, court will set Mr. Aaron White then for docket call on April 14th. That'll be at 9 a.m. After you get the yellow copy and sign, you're free to go. Okay. So we don't need to. Dakota White, CR 21-375. All right, Mr. White is set for pre-trial.
Yes, Your Honor. Once again, I don't believe there's anything contested on this. We have gotten into some preliminary negotiations. I fully expect that possibly by the next docket, we will have this resolved.
Court will set Mr. White then for docket call on April 14th, 9 a.m. Sir, thank you, Mr. White. Mr. Walter, you ready? Is this one of your cases or Mr. Moore's?
It's Mr. Moore, page 3. He's Richard Sutton. 4. Well, the one on the table said 3.
Richard Allen Sutton, CR 21-250. That's fine. No rush. All right, Mr. Sutton is set for pre-trial today. Mr. Waldron.
He is, Judge. Judge, I think we can reset this for a plea date. This being reduced to a misdemeanor. But if we could reset that for a plea date, I think we get it resolved by then.
Do you know if Mr. Moore has any contested pretrial issues that he's filed?
No contested pretrial issues. There was a disc that we obtained. Apparently that disc body cam video is not working. But based on where we are with plea negotiations, it's going to be a moot point, I believe.
I can set for docket call, and if y'all plead that day, great. If you don't, then
My suggestion would be to set it for a document call, just so we don't change any timelines of Mr. Sutton's first time. I had called my declaration before that next day, just to set it for not to call. Just last much time.
Available, or Mr. Moore available on April 14th? Fourteenth will work, Judge. That's fine. Excellent. All right. We'll set Mr. Sutton in for April 14th at 9 a.m. for docket call. Mr. Sutton, once you sign and get the yellow copy from Mr. Waldron, then you're free to go, sir.
Thank you, Your Honor.
You're very welcome. Here's looking good. I know, hey, I'm a fan. Mr. Ashmore, are you ready on anyone? If you need more time, that's fine. I've got some other people I know. Pretty boy.
She is the person who texted call. Said that she had some morning sickness. I advised her that I visit with the court about perhaps showing up 1:30 docket. But then she should get here, she can either enjoy morning sickness at home or in the orange pajamas. And apparently she's talking to the state room too, and she's on her way. So I'll just ask the court's patience and not to issue a nice sign of bond insufficient because we are here to plead on her case this morning.
Was she playing to probation or time?
Defer.
Defer. Yes. We'll give her time.
Okay. Thanks, sir. I'll get my people out of the hall. We're ready to go on several.
Okay. Yeah, if you'll go ahead and start rounding them up. Mr. Eastley, can I visit with you? Stay. This is cause number CR 21293, State of Texas versus Philip Andrew Hollister. Mr. Hollister was set to enter a plea today to what appears to be probation sentence of 2 years in TDC, suspended and probated for 5 years, along with some fines and court costs. Mr. Hollister, it's come to my attention that you are currently intoxicated. I don't want you to say anything. You're here with your attorney, Mr. Eastland. I've discussed this with him. The officers are well aware of your situation. Mr. Officer Everett here has indicated that he has administered a portable breath test at my direction. Because people in the courthouse all knew that you were intoxicated by the way you were talking, by the way that you were walking. It's not something that you can disguise. So Officer Everett did that at my direction. On the basis of you being intoxicated by way of the portable breath test, the court's going to find today that your bail is insufficient, Mr. Hollister. I'm going to place you in custody at this time. We're going to reset your case, and I'm going to allow your attorney, Mr. Eastland, to work with the state's attorney to determine what's going to happen on your case after today. Okay. All right. So I'm going to go ahead and take you into custody at this time. Please go ahead. Mr. Stevens, you ready? Heather Keels. All right, Ms. Keels, this is cause number CR 21330, and you are set for docket calls. Mr. Todd, can I have y'all just stop for a second, because I'm not sure she can hear me. If you are inside, it's okay, no problem. And Ms. Keels is set for docket call today. Mr. Stevens, go ahead.
Yes, Your Honor. Judge, we're going to ask for another docket call. Actually, we're going to ask for it after April the 25th. The reason being, she has pending charges out of Hunt County, and she's trying to find out what's going to happen in Hunt County before she proceeds on this case. This case has been offered either deferred probation or some small time. I believe Hunt County is headed the same way. So she's trying to get figured out what she's going to do, Judge. So with that being said, that's why we're asking for another docket call beyond April.
Any objection from the state?
No, Your Honor. Mr. Stevens and I have been in discussions. I will also confirm.
All right, court will set Ms. Keels then for April 26th.
Your Honor?
You said after the 25th, right?
Yes, sir. Oh, yeah, thanks. Okay. So to speak.
What about May 10th?
No, I think it has to be in orders.
Yes, sir.
All right, court will set Ms. Keels for docket call on May 10th. That will be at 9 a.m. Ms. Keels, I show that you're delinquent on your attorney fees and your bond supervision. So and you were late today. So what I'm going to do, Ms. Keels, is Mr. Stevens is going to give you this notice of appearance. Once you sign the yellow copy, I want you to report over here to pretrial release, and I'm going to drug test you.
Yes, sir.
Okay. If you're in violation, then you're going to stay with me today. If you're not, then you'll go home. Okay.
Sir.
Ms. Kills, you come up here and have a seat, and then the probation officer will be with you shortly.
That's all I have this morning, Judge, might be excused.
Yes, thank you, Mr.
Thanks,
Stevens.
Judge, I'll see you this afternoon.
Joshua, are you ready on anyone?
Judge, we're ready on Kate Mitchell.
Caden Robert Mitchell, CR 21-403 and 406.
Judge, we're here on a pretrial.
Let Mr. Mitchell get up here, so. be part of it. All right, go ahead, Mr. Ashman.
Judge, we're here on a pretrial. We don't believe there's going to be any contested pretrial matters. We're asking the court to set us on a docket call. We have an offer from the state of 4 deferred. No alcohol as a condition on the 3rd-degree felony prohibited substance in the correction facility, and then reduce the DWI to a first, run those 2 offenses concurrent. We're asking the court some time to consider that, reset us for a quick turnaround to resolve this matter.
State. So you want to set for docket call?
Yes, Judge.
All right, I can set April 14th.
That works. Thank you, Judge.
All right, Mr. Mitchell, I'm going to set you for for docket call on April 14th at 9 a.m. Once you sign and get the yellow copy with Mr. Ashmore, then you're free to go, sir. All right, Mr. Ashmore.
Judge Ladary Ward.
Ladary Ward, CR 21-397.
Judge, we're here on an arraignment. Judge, my client has seen the indictment. He's confirmed that his name is spelled correctly both places. He understands the nature of the allegations, that this is a state jail felony. We've talked about the range of punishment. He's authorized me to formally waive the reading and enter into negotiations with the state of Texas on this. We do have a plea offer of 2 deferred with a $1,500 fine. Mr. Ladary and I are going to ask the court to reset this for a pretrial so we can formalize this agreement, which we believe will be back to resolve this at our next setting. And if the 14th is also available, set it that same day.
All right, then court finds that Mr. Ward has waived the formal reading of the indictment, and the court will enter his plea of not guilty into the record. Court will set Mr. Ward for a pretrial on April 14th at 9 a.m. Mr. Ward, once you sign and get the yellow copy, you're free to go. Sure you send a copy of this. Mr. Ashmore.
Laura Foley, Your Honor.
Laura Foley. CR 21262, separate docket call.
Judge, we are waiting on I think we're waiting on a ruling. That's my responsibility. I should have pushed the court up. We have a request that the state's not opposing for a mental evaluation. We asked for the evaluator that was used in Grace Fowler's case. I think the court's got that under advisement, and we don't have a signed order on that. And I was supposed to be in trial in February, and now I'm in trial in the month of March, and I let this fall off my radar. So I apologize. I accept responsibility for that. I'm not trying to slow the court's business down. We still need that order. I also know that there's been some, I don't know if it's conflation. There's a CPS case, and there's an evaluation that's supposed to happen in that court. Whether the two were thought to be the same, I think that's a different evaluation. I know Miss Linda Bush, who's Laura Foley's attorney down there in the CPS
I'm
court.
sure that's a psychological evaluation.
It's a family custody, family code evaluation, so it's similar but different. It doesn't have the same
Legal competency component.
Yeah, maybe that was the slowdown, but regardless, I have been in touch with Ms. Bush about it. And maybe that's part of that slowdown anyway. We just need the court to rule on who's the evaluator going to be in our matter, and then reset it for some time for that evaluation to be completed. We have that information. We can get a plea offer from the state, move forward.
All right, court will grant the motion suggesting incompetency and will order an examination of Ms. Foley, Dr. Ingram. And at this point, I don't find that there's another evaluator that's going to be evaluating her on the basis of legal competency. If that were occurring in the CPS court, if there was an issue of competency raised down there, if that was brought to my attention, I would consider doing that. But at this time, I don't see anything in the record before me that would allow me to trust that there's an evaluation going on in another case that could be used by this court to determine legal competency. So we'll get that order signed and we'll be in contact. Let's make sure that we have the best contact information for Ms. Foley. And we'll do that, get that, and give that to Ms. Taberham so we can pass that on to Dr. Hayman so we can set up an interview with her.
Okay, thanks, Judge. And then
we'll set this for status. And we'll set this a little further out. Let's look at May. Are you available May 10th or 12th?
yes, Judge.
Either one of those preferable.
5:10 works great.
All right, court will set Ms. Foley then for status on the evaluation. May 10th at 20.
This Foley will wait to visit me after we're done with our business and make sure Ms. Taylor has the appropriate contact.
All right, thank you. All right, do you have anyone else?
Mr. Gutierrez, Judge.
Damon Gutierrez.
Judge, we're here on a docket call. We're asking the court for an additional docket call so we can lock down our plea agreement with the state of Texas. We were close on it. We haven't had time to formalize it, get our paperwork. The offer is 3 deferred, $2,000 fine, 180 hours of community supervision, which has been tentatively approved by probation. We're asking the court for a quick reset on this so we can lock this agreement in and get Mr. Gutierrez business concluded.
All right, any objection from the state? All right, court will set Mr. Gutierrez on April 14th for an additional docket call. Once you sign, you'll be free to leave.
Whenever you're ready, Judge, we have one.
Yeah, who are you ready?
Mr. Tashner, Jesse Tashner.
Jesse Tashner, CR 21393.
Judge, we're here on plea deferred on Mr. Tashner's matter. Just 1 second.
Yeah, you may, I'm sorry. All right, Mr. Tashner, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Tashner, your name is Jesse James Tashner, is that correct?
Yes, sir.
And Mr. Tashner, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Sir.
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this case or the paperwork that you've read and signed today that you do not understand?
Yes, sir.
Mr. Ashmore, do you believe Mr. Tashner to be competent today?
I do, Your Honor.
Have you explained to him his legal rights and all of the admonishments contained in the paperwork today?
We have, Judge. We've talked about the benefits and consequences of a third-degree deferred, that it works in a lot of ways to simplify, like a traffic ticket deferred. If you don't get caught speeding again, don't break the law again, this will go away after the end of the probation period. And then if he messes it up, it opens him up to the full punishment range of 2 to 10 years, either through sanctions or motions to revoke. He's well aware of all that and excited to get about his business because he wants to restore his rights as a citizen. Rephrase, he wants the opportunity to restore his rights as a citizen.
All right, and I see that the proposed plea is that Mr. Tashner is going to plead guilty to a third-degree felony offense of possession of a controlled substance between 1 gram and 4 grams. The recommendation is that a finding of guilt be deferred, and that he be placed on 3 years community supervision, that he pays a $2,500 fine, plus court costs, restitution, and reimbursement fees. Is that your understanding of the plea, Mr. Tashner?
Yes, sir.
Yours as well, Mr. Ashmore.
Yes, Judge.
All right, Mr. Tashner, you are indicted with a third-degree felony offense of possession of a controlled substance of penalty group 1 greater than or equal to 1 gram but less than 4 grams that carries a range of punishment if convicted and sentenced of a minimum 2 years to a maximum 10 years and a fine of not more than $10,000 optional. Do you understand that?
Yes, sir.
Do you understand that if I approve this probation agreement today and I defer a finding of guilt, that means I do not convict you of this offense today, that I accept your plea of guilt, I take that into consideration, I place you on probation. If during that term of probation you violate any one of the conditions, the state can file a motion to adjudicate your guilt. That means to convict you and can bring you back before the court, ask the court to conduct a hearing about that violation. And if the court finds that you violated, I could adjudicate you, convict you, revoke your community supervision, and I could assess your punishment anywhere within that range, from the minimum 2 to the maximum 10 years in prison. You understand that?
Yes, sir.
Understanding the plea agreement, understanding the potential risk and the range of punishment, do you still wish to go forward with the plea today?
Yes, sir.
All right, Mr. Tasher, I want to ask you at this time, how do you plead to that offense?
Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
Court accepts Mr. Tasher's plea of guilt. Mr. Ashmore, any objection to the state's evidence?
No, Your Honor.
Our state's evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor. Request closing today.
from the defense?
No, Your Honor.
And Mr. Tasher, are you a resident of Texas?
Yes, sir. Fort Worth.
Okay. I saw an office report. It said you're from South Carolina.
I moved here from South Carolina.
Okay. All right, Mr. Tasher, the court has reviewed the evidence, and I do find enough evidence to convict you of this offense. The court will follow the plea agreement that you've reached with the state. The court hereby defers the finding of guilt on possession of controlled substance from the group 1 greater than or equal to 1 gram, less than 4 grams. Court places you on community supervision for a period of 3 years, orders you to pay a $2,500 fine, $180 restitution, $290 court cost, and $785 reimbursement fees. Court hereby commands you to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms of the conditions of the sentence. I'm gonna have you step forward here to be fingerprinted by the bailiff. After that, I want you to report over here to the probation officers.
I think so.
You may. This one got away. Mr. Ashmore, are you ready on anyone else?
No, I'm gonna ask to be excused to the jail.
Okay.
And I don't know if, Well, maybe we should call Mr. White's case. I probably should make an announcement on that. I'll leave that to your discretion where it needs to be on the record. He's the homeless kid who was out front in February, breathing. Had some COVID-like symptoms, didn't want to come in. He took off to get warm before he was handed his reset slip. You understand? He's out at a convenience store. We've tried to send it there, call there. I think Mr. Waddell's tried to catch him there. And I just don't know if he was in such a hurry to leave because he was cold. But I don't know if he had actual constitutional notice of this next setting, what that means for his bond, what have you.
Now back up, remind me again.
He's homeless. He's a young skinny kid. He was out front in the courthouse and he was wearing the duck trousers with no shirt.
Since I wasn't out there, I don't remember.
Yeah, he was on Zoom because he had COVID-like symptoms and we just encouraged him to not come in.
Did I tell him on Zoom when to be back in court? Did I announce that?
I don't remember. My thought is yes, but before Joe Craddock, my colleague, was outside with the computer.
I do recall that.
And I went downstairs with the reset form, but he was cold and he left. So.
We'll see if he shows up before noon.
Okay, Judge.
If he does, I'll let you know. If he doesn't, I'll have a warm spot for him at the gym.
Understood.
It's not always, most of the time. And then if you're heading out
Warm in
there,
August.
you're heading out to the jail, you said?
Going to the jail to see Mr. Willis.
All right, and so still, is Rebecca Hunter here? You are? Okay, you want to go speak with her? Sure. Mr. Schmidt, are you ready? Okay. You ready, Mr. Hand? Yes. Joshua Hand? All right, Mr. Hand, if you'll raise your right hand, this is cause number CR 21168. Mr. Hand, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may go. You are Joshua Ray Hand, is that right? Yes, Your Honor. And Mr. Hand, are you a United States citizen? Yes. Do you read, write, and speak English? Yes. Have you ever been diagnosed with any type of mental condition? What have you been diagnosed with?
Manic bipolar depression, anxiety, PTSD.
Are you currently on any medications for those?
Yes, sir. Currently in this condition, he is on. He is already taking tests to set that up, so I understand. So the board does, it is an issue.
Okay, but is there any reason to believe, Mr. Schmidt, that he's not competent today because he's not on any of those medications? That's really what my question is geared at, is if you're not on medications for those today, do you feel like you have a rational understanding of what's going on here today? Okay. And in this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you? Yes, sir. Feel like you've had enough time to discuss your case with him and have all your legal questions answered? Yes, sir. Is there anything about this paperwork that you've read and signed with him that you do not understand? Mr. Schmidt, you do believe Mr. Hand to be competent based on your former statement?
I do, Judge, based on the statements of this paperwork.
I see that Mr. Hand is indicted with a third-degree felony offense of evading arrest with detention with a vehicle. It carries a range of punishment of not less than 2 years or more than 10 years if you were convicted and sentenced on that crime. I see that the recommendation from the state is that Mr. Hand would plead guilty to that charge in exchange for their recommendation and plea agreement of 10 years confinement in TDC with that being suspended and Mr. Hand being placed on community supervision for 10 years, paying a $1,500 fine plus court costs, reimbursement fees, and restitution. And as a condition of this plea agreement, there are 1, 2, 3, 4, 5 charges being taken into consideration. Is that your understanding, Mr. Hand? Yours as well, Mr. Smith? That's correct. All right, Mr. Hand, understanding that the range of punishment is 2 to 10 and an optional fine not to exceed $10,000, and you understand what the plea agreement is, do you still wish to go forward? Yes, sir. All right, Mr. Hand, how do you plead to evading arrest? How do you plead to the 3rd-degree felony offense of evading arrest for detention with a vehicle? Guilty, sir. And Mr. Hand, are you pleading guilty of that crime because you are guilty of committing that crime? Yes, sir. Has anyone threatened, forced, or pressured you to plead guilty today? Yes, sir. Court accepts Mr. Hand's plea of guilt. Mr. Schmidt, any objection to the state's evidence? No. Our state's evidence is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? No, Your Honor. From the defense? And you said that one of the conditions, Mr. Schmidt, is that he needs to be placed on a mental health caseload with treatment through the Intoxication Center. That's correct. All right, so is there an agreement to?
It should be in there. We are
Yeah, it's not reflected in the agreement. It is reflected in the indictment. Do you want to mark through the enhancement paragraph? I mean, that way if this ends up later time being reviewed by TDC, they'll know that you abandoned that.
Just want me to strike through it,
I'll
Judge?
just strike through it. All right, court's reviewed the evidence. I do find sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement in this case. Court hereby convicts Joshua Ray Hand of the 3rd-degree felony offense of evading arrest or detention with a vehicle. The court sentences him to 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will suspend that sentence today and place him on community supervision for 10 years. Court orders him to pay a $1,500 fine, $180 restitution, $290 court cost, and $130 in reimbursement fees. Court takes into consideration under section 1245, driving while license invalid with previous conviction, criminal mischief 750 to 2,500, possession of controlled substance 1 to 4, and evading arrest or detention with previous conviction, and also reckless driving. Do we have our attorneys here for the interpreter? Is Mr. Manning one of them? English man is here, but the interpreters.
Mr. Manning on the Zoom, Judge.
All right, Mr. Hand. Court hereby remands you to the custody of the Van Zandt County Community Supervision and Corrections Department, so they carry out the terms and conditions of the sentence. And have you step forward with the deputy to be fingerprinted. After that time, we'll join the probation officers over here, and they'll give you more information. Yes, everything this afternoon. There's something.
Good morning. Can y'all hear me?
Yes, sir. I'm sitting here talking to you, but I was muted and I had my camera off, so I was really testing you this morning, Mr. Damon. How are you?
I'm good, Your Honor. How are you doing?
I'm doing fine. If I can get it all together. All right, this is cause number CR 2404, State versus Jason Lee Mulligan, and we are set for pretrial today. Are there any contested pretrial motions or pretrial issues, Mr. Damon, that we need to go over?
Not at this time, Your Honor. I have not fully completed discovery yet. I have all written discovery. I received the offer in that and related to my clients, but I have not yet picked up the media from the district attorney's office. I believe I owe them some blank discs. I will be there in a couple weeks, and I anticipate doing it at that time.
So you've got written, you don't have digital.
Yes, Your Honor.
All right, so what I'm going to do is I'm going to go ahead and set this for docket call, and I'm going to set it. Are you available on April 14th?
Let me look, Your Honor. I believe so. April 14th. Yes, Judge, I am.
All right, I'm going to set this for a docket call on April 14th. And if there are any pretrial issues that emerge from the DVD discovery, you'll let me know. And then
Absolutely.
We'll talk about getting those set. Okay.
There's one issue that I did want to address with the court. My client recently had some medical issues. He had to go to the hospital. They do suspect that he might have throat cancer. I just want to let the court know that if there's anything that might, interfere with him appearing as far as immediate medical concerns, that might come up in the future.
Okay. Well, if there's an issue on the 14th, then you'll just let me know. File a continuance, let the state know. If they agree, then we'll get it reset and we'll work around what he needs to do.
Absolutely, Your Honor.
All right, we had him sign a notice. He's got the yellow copy. So Mr. Mulligan, you're free to go.
Thank you, Your Honor.
Thank you, Mr. Don. I appreciate it.
Thank you. Am I excused?
Yes, sir, you're excused.
Thank you.
Mr. Ashmore, are you ready? Ms. Hunter? Yeah. Rebecca Hunter, if you'll come forward, CR 21387.
We're here on a,
Letter conversation. All right, you're on pretrial. Go ahead.
Judge, we're here on pretrial. We do not believe that we are going to have any contested pretrial matters. We have a plea offer from the state of Texas, 3 deferred, $1,000 fine. I would like an opportunity to visit some more with my client, ask the court to reset this for a docket call so we can get our agreement ironed out and any other things that we may need to visit with the state about to finalize this. So that's our request. Also, Ms. Hunter doesn't have a vehicle, so she has expressed to me that she's sorry for her tardiness and for delaying the court's business today. It was not intentional.
Okay, I appreciate that. All right, court will set Ms. Hunter then for a docket call on April 14th at 9 a.m. Yes, thank you. Yes, thank you. All right, Ms. Keels, if you'll come back over here. We're going to go back on the record, cause number CR 21330. All right, this is State versus Heather Flynn Keels. The court has already set her for docket call on May 10th. All right, accepted the announcement from Mr. Stevens. Ms. Keels, I've asked the pretrial release department to conduct a urinalysis of you to see if you're in compliance with court orders. Ms. Burns, did you do that?
Officer Richard.
Officer Mature, did you conduct the urinalysis exam of Heather Keels?
We did not do the exam, she admitted.
What did she admit to?
She admitted to smoking marijuana on February the 9th and drinking alcohol March the 5th.
Skills, you understand that's a violation of your pretrial release orders? I can't, I'm sorry, speak up.
So yes, sir, I wanted to be honest with you about this. Married to my friends this past week. And it's just been a little hard.
No, I understand, but you understand it's a violation of orders. You can't be under indictment for felony drugs, and be on bond, smoking marijuana and drinking alcohol. You do understand that, right? And I appreciate you being honest. I mean, if you weren't honest with me, then it would get worse for you. I mean, it's going to drug test you either way. And I was going to find out. So, Ms. Kills, at this time, I'm going to find that you violated the orders of this court. The court's going to find your bail to be insufficient. Place you in custody at this time. I'm going to increase your bail in this case. All right, so take Ms. Kills into custody. Mr. Harden, are you ready? Or Mr. Todd, either one of you jumping ready?
I am, but he's
You ready?
here.
I think, second line on the desk.
Okay.
That is finished, that's the paperwork.
All right. Tanner Sister, CR 21189. All right, this is cause number CR 21189. And before we go any further, so it was brought to my attention that there was some discussion about the weapon that was alleged to be used in this commission of this offense and with regards to the plea today. And so is that still an issue?
Well, let me clear it up for the court. If the court will look at paragraph 12 with stipulation of evidence, the complaining witness described the shotgun, and that was the weapon that he had in his possession. However, later after they left the scene, the deputy saw a rifle laying on top of the gun cases in the back seat and encouraged, I think, the witness to describe a rifle instead of a shotgun. My client has possession of that shotgun, which he admits that he had in his possession at the time of the offense, and will be willing to surrender that gun to the court. The other issue is that it's my understanding now that the court's policy is that they destroy the weapon and won't release the county. We would ask the court to permit us to surrender the proper weapon and retrieve a gun that did not belong to my client that was in the vehicle at the same time.
State. So paragraph 12, this individual named Brooke indicated that she believed it to be a shotgun. And so you're saying, yeah, okay, so 13, deputy asked for a description. It's described as a brown shotgun. But then she stated that she believed it was a rifle due to due to how narrow the barrel was. So tell me again, Mr. Harden, that he admits that it was a rifle and not a shotgun. But what he had in his possession at the time of arrest was a shotgun?
He had in his possession in the vehicle at the time of the stop in front of the house. He had a shotgun in his possession. But at the time that they stopped the vehicle, which was down the road, they had already left the scene. And at that point in time, all the weapons had been put into the back seat. Only weapon that was not in a case at that point in time was the rifle that they seized.
What kind of rifle is it that Mr. Sistrok's saying that he used?
Saying that he had the at the time of the offense, he had the shotgun in his front seat.
Right. But I'm saying, what is he saying that he used? He's saying that he didn't use the shotgun, he used a rifle. What kind of rifle is he saying that he used?
There was multiple rifles in the vehicle and a pistol as well. But the one I had in the front seat with me was a shotgun. But they were all in cases except for the one rifle in the case.
Right, but this allegation is that you pointed a firearm at someone. What are you admitting that you pointed at the shotgun?
That's what she had described it. The story's been changed on her. She had said.
So
shotgun is what I had in the front seat is what she had seen.
And that's what was seized?
That was the weapon that was used, my understanding.
So what I'm hearing is what he's saying he had in the front seat that was viewed by the alleged victim at this point is the shotgun.
Correct.
Well, they're actually both. One on the left side, one on the right side. The one that was on my side, was the shotgun. When we had left the scene, we put everything in the back seat.
Judge, I believe the rifle is what we have
They did.
in our possession.
You have the rifle. And you want to exchange the shotgun
I want to surrender the proper weapon to the court and.
I'm saying, what is that? What is the proper weapon?
Yes.
What gauge, what brand, what model?
20 gauge. I don't recall the model where it's 20 gauge. I remember that. But I don't remember which brand I think it was.
And what do we have in the possession of the law enforcement agency right now?
Browning VAR 7mm.
And you're saying that was also in the truck?
Yes, sir. Along with multiple others.
But you're saying that was up front with the shotgun and visible by the
yes, sir.
alleged victim? So the victim's describing a shot, they're saying the word shotgun, describing a rifle. And do you contend today, I mean, you're pleading guilty to, it looks like probably a lesser included, or it looks like a class A misdemeanor deadly conduct. Is your client contending today that he did point the weapon at Brooke?
Yes, Your Honor.
And what weapon does he say that he pointed at her?
Shotgun.
Okay, because I've heard you say they were both up front.
One was on the passenger side, one was on the driver's side.
Right, but I'm talking about which one did he point at her? I don't care where they are in the truck. I want to know which one he held in his hands and pointed at her. Shotgun. State. Y'all want to stop and let me work with Mr. Todd and y'all kind of work through this issue. Okay, y'all do that. So go ahead and have a seat, Mr. Sistrok. Let them keep talking. We'll get to a point where we get it figured out. Mr. Todd, if you'll come on up.
Yes, sir.
Maria's on there, right? I'm gonna go ahead and get Mr. Todd out of there.
I have two today, Judge.
All right. Are you any order preference? You care?
Well, we can do Ms. Walker first because we entered an agreement with the state. We just need to get a plea date for that.
Keanu Walker, CR 21-312. All right, Mr. Walker, set for docket call. Go ahead, Mr. Todd.
Your Honor, I have had conversations with the state, presented them with some information. They extended a plea offer that we will be accepting after consultation with my client, and I'm just requesting a plea date.
All right. Are you available April 12th? I'm sorry, April 14th.
I looked at that one earlier. Yes, sir, I am.
April 14th. I'm sorry, I misspoke. I've already filled that date up. All right, Ms. Walker, I'm going to set you to enter your plea before the court on April 14th at 9 a.m. Once you sign and get this yellow copy with Mr. Todd, you're free to go.
Thank you.
Keith Thomas.
But the doctor said, we'll proceed on one step below. Allegation.
All right, are you Keith LaTroy Thomas?
Yes, sir.
Mr. Thomas, if you'll raise your right hand, sir, with place under oath. Mr. Thomas, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, okay, put your hand down. Mr. Thomas, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Michael Todd. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to discuss your case with him, have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
Sir.
Mr. Todd, do you believe your client to be competent today?
He is, Your Honor.
Have you explained to him his legal rights with regards to this case?
I have, Your Honor.
Do you believe he understands them?
I do, Your Honor.
Have you also discussed with him the advantages and disadvantages of a deferred adjudication plea?
I went over extensively, yes, Your
You
Honor.
believe he understands those as well?
He does, Your Honor.
All right, Mr. Thomas, you are charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams. However, the plea agreement today calls for you to plead guilty to a third-degree lesser included offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams. A third-degree felony, if convicted and sentenced, carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and also carries an optional fine not to exceed $10,000. I see that the plea agreement in this case is that you would plead guilty to that third-degree felony in exchange for the state's recommendation that the court defer a finding of guilt today. That means that the court not convict you of this offense today and place you on 3 years community supervision with a $2,500 fine plus court costs and restitution, and also dismissing and taking into consideration a misdemeanor charge of possession of marijuana less than 2 ounces. Is that your understanding of the plea agreement?
Yes, sir.
So understanding the plea agreement, understanding the range of punishment, you still wish to go forward?
Yes, sir.
And you understand that if I prove this today and place you on community supervision, if at a later point during that period you violate any condition of your community supervision, the state could file a motion to bring you back before the court to have a hearing. And if the court finds that you violated any of the conditions of your probation, the court could convict you at that time. The court could revoke your community supervision and could assess your punishment anywhere between 2 years to the maximum 10 years.
Yes, sir.
Understanding those things, you still want to go forward?
Yes, sir.
All right. So at this time, I'll ask you, Mr. Thomas, how do you plead to possession of a controlled substance in penalty group 1 greater than or equal to 1 gram, less than 4 grams? Yes. And Mr. Thomas, are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
The court will accept the defendant's plea of guilt. Mr. Todd, any objection to the state's evidence?
No objection, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor. Just a
From the defense?
That's in close, Your Honor.
All right, the court's reviewed the evidence. I do find sufficient evidence to convict Mr. Thomas of this offense. The court will follow the plea agreement in this case. The court hereby defers a finding of guilt on the third-degree felony offense of possession of controlled substance, penalty group 1, greater than or equal to 1 gram, less than 4 grams. The court will place Mr. Thomas on 3 years community supervision. The court will order him to pay a $2,500 fine, $290 court cost, $180 restitution, and $35 reimbursement fees. The court dismisses, as it takes into consideration DA 2021-315, for possession of marijuana less than 2 analysis. All right, Mr. Thomas, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the deputy. After that time, step over to your left with the community supervision officers, and they'll give you more information.
Thank you, Your Honor.
Thank you, Mr. Todd. Good to see you.
You too, Judge. I'll be excused.
Yes, sir, absolutely.
Good morning, Your Honor.
Good morning, ma'am. Can you see and hear me okay?
I can see you very well, Your Honor. I just want to inform the court that your interpreter does have another hearing at 11:15, regretfully,
Okay, I believe
that I
that,
must honor. Okay.
I believe that we'll be done in time for that. All right, you'll go ahead and state your name and your license number for the record, and then I'll place you under oath.
The court's interpreter's name is Maria T. Villiers with state license number 816.
Ms. DeVillers, will you raise your right hand so I can place you under oath? Ma'am, do you solemnly swear that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God?
As I raise my right hand, I do swear.
All right, and let me go ahead and turn on the, should have already done that, but I'm a little bit behind here. Let me get you hooked up.
Is the court going to access the interpreting channels for simultaneous? Excellent. Should
I
I?
want you to take this opportunity to introduce yourself to Mr. Herrera.
Thank you.
Jose Herrera, and see if he has
Thank
any
you.
questions at this
Thank you so much. Señor José Herrera, buenos días. No puedo, tiene que abrir su micrófono. Dígale a la señorita que estaba con usted que abra su micrófono. Ma'am, if you could be so kind to stay that way, you can help him join the interpreter's
You're likely to have to
channel.
unmute his laptop, I think.
I've already asked to do that. Perfecto. ¿Me puede escuchar, señor Herrera? Señor Herrera, ¿puede hablar? He doesn't seem to be hearing me. Señor Herrera,
Make
¿me
sure
puede oír?
that he's not muted on the clip.
¿Me puede oír? 1, 2, 3, 1, 1. I believe the
Should go down
mic
to
is.
Spanish channel.
The interpreter will go to the Spanish channel, but she will lose communication with Mr. Herrera if he's not joined.
Have him. Ask both of you. I'm going to mute you back.
Sí. Sí, lo escucho.
All right, I had to mute his device. Go ahead and ask him if he can still hear you, just to make sure.
Sí, sí, lo escucho.
All right, this is, thank you, I'm sorry. This is cause number CR 21290, CR 21316, State of Texas versus Jose Guadalupe Rivera Herrera. And Mr. Manning, I believe that we are set for pretrial hearing in each case. And you're on mute, Mr. Manning.
Yes, Judge. We have received a new offer from the state. I've discussed that with my client. We would request that he would have some opportunity to review that with an immigration attorney to see how that would affect his immigration status. I don't know what dates are available. If we could set it a little bit longer so we'd have time to consult with the immigration attorney, find one, and be able to discuss that with them.
Do you have any contested pretrial motions that we need to put on the docket?
No, Judge, we do not have any contested at this time.
All right, any objection from the state to setting Mr. Herrera a little bit later in April, maybe April 26th?
No objection, Your Honor.
Are you available on April 26th, Mr. Manning?
Okay.
Judge, I'm sure I can be.
It would be at, actually, I usually check with you, Ms. Villers, to see if there's any availability for interpreter. So do you have the OCA interpreter schedules available? Let's see if we could. Yes, ma'am, please do.
Okay.
Did you say 11:30? Yes, please. We'll set Mr. Herrera then for docket call hearings on April 26th at 11:30.
Sí, está bien.
And before he leaves, if you'll just ask if he has any further questions of his attorney or the court.
No. No, está bien.
All right, thank you. All right, so I want you to tell Mr. Herrera that I do show that he is delinquent on his pretrial release fees, and that he should report to the officers here in the courtroom to talk about making a payment towards his court attorney fees and bond supervision fees. And he's delinquent $240. Do you understand?
Okay, sí, está bien.
All right, then we'll be adjourned, and he can meet with the pretrial release officers over here, and he's free to go. Good. Yes, thank you, Ms. Villers. I appreciate it. Yes. No preference. However y'all want to do that, whatever's easiest for y'all. Y'all have all done a great job. So however you want to do it. Thank you. Yes, ma'am. You have a great day. All right, Mr. Manning, anything further?
Yes, Judge, I have Mr. James Johnson on the docket.
Mr. Johnson, could come forward. All right, this is cause number CR 21294, State versus James Paul Johnson II, set for pretrial.
Yes, Judge. This is our first pretrial setting. I received all the discovery. However, when I attempted to play the video files provided by the state, they were not working. I've attempted to troubleshoot that on my own, but I wasn't unable to get them working before this pretrial. So I asked for an additional pretrial so I can get the videos redone, view those, and then we can move on to our next setting.
All right, court will reset the defendant for, are you available on April 14th?
One moment, Judge. I will be in Henderson County in the morning, but I can be available later that morning or in the afternoon.
What about April 12th?
April 12th, that will work.
Okay. All right. We'll set Mr. Johnson then for pretrial April 12th at 9 a.m.
Yes, Judge.
State if you'll make a note for Ms. Abney or someone
I
else.
made a note if Mr. Manning would contact my office, he can't do it working, and we will see if we can get another copy, however we can do that to ensure he has that prior to that date.
Do you hear that, Mr. Manning?
I believe so, Judge.
Yeah, so your microphone's on. So, Mr. Woodwide just asked if you'd contact his office to coordinate, trying to troubleshoot that and or getting new copies.
Yes, Judge.
All right, let's see, Mr. Johnson, you're free to go. Is that all you have, Mr. Manning?
I do. I appreciate the accommodation, and I will look forward to seeing you guys soon.
Yep, very well.
Thank you, Judge.
All right, let's see here. Mr. Crawford will be by Zoom. And that's Miss Newton at 11:30. All right. We have any progress on Mr. Sister? Yes. Mr. Lejeune. All right, this is cause number CR 21402, State versus John William Lejeune Jr. Mr. Lejeune, I set you today on a status of whether or not you've hired your attorney. Have you hired anyone to represent you?
No, I met with Mr. Noel White and I know the retainer and I put in a loan and I'm waiting for the results. The loan officer said they're kind of backed up due to COVID, but I should get the results here in the next few weeks.
So if I give you an additional 30 days, you feel confident that you'll be able to hire Mr. White or someone else?
Yes, absolutely.
All right, so the court will reset Mr. Lejeune and we will set him on April 14th for a status on hiring an attorney. So once you sign this copy and get the yellow copy, then I'm gonna have pretrial release papers. You'll come over and meet with these officers and they'll give you more information. All right, so Mr. Sistro, if you understand, we'll see you back here at 1:30. So, okay.
Judge, what, Mr. Sister, hold on just a second. Does that work for everybody? And surrender the shotgun to Deputy McLeish at 1:30, and then we don't have to worry about him bringing it in the later date. It will be in judgment. Does that work for everybody?
As long as they're gonna probably want to let them come and get it out of his car rather than him try to carry it in there. You comfortable with that, Deputy McLeish? You understand what we're trying to do?
That or I could disassemble it. I mean,
You understand what we're trying to do? I'm trying to get one out and one in. Okay. Okay. So.
I'll be at the front, so you guys in on it.
Well, we're talking about having them bring that out to you at the sheriff's office. Yeah, not here. Not here. Yeah.
Okay. Yes, sir.
Okay, so let's do this. Yeah, you go get the weapon, okay? Have it in your car and then take it out to the sheriff's office, leave it in your car. And then you'll go in and notify them that you're there to see Deputy McLeish, right? Deputy Aaron McLeish. And then she'll come out, she'll take that and then we'll work on the paperwork to do the swap. Are you gonna be able to have it to where you could release one to him while they're there?
I've asked the staff to get a
Disposition.
for me today, so we can just do a swap.
Okay, that way she can take it out of her inventory, so to speak, and take it back to his car.
It is going to be eligible for convictions. Yes.
Well, it's not going to be deferred as a conviction, but it's, so it should actually say that it should, yeah.
So, I'll just do, actually, right inside the center.
Thank you, yeah. I think it'll make it easier on you, and I think it'll make it easier on him as well. Yeah. No, I don't need him anymore. He's free to go. I was just telling him we're gonna come back here at 1:30 to finish up. So you're good to go. Most definitely. Good morning, Mr. Crawford. How are you, sir?
Fine, thank you, Judge. Morning.
Good morning. All right. I got Ms. Newton here. Can you see her okay?
Yes, sir.
All right. This is cause numbers CR 21, 134, 35, 333, 334, 335, State versus Shelby Diane Newton, and we are set for docket call today. Is there any announcement from the defense or the state?
We're ready for trial.
So all offers and counter offers have been made, negotiations have all been done, and we're ready for trial. We both sides understand that once we ask for a trial, of course, I'm going to entertain a plea.
I haven't had an offer I can settle for.
Your Honor, this is Ms. Curry's case. She's been working on this with Mr. Crawford. I'm not aware if there is a current offer, if there ever has been. I know we've all been discussing trial since the very beginning of this. My understanding was that even if we had an offer, that there wasn't much interest in one. I don't know what Ms. Curry's position is, but it is my understanding that we are all moving towards a trial on these.
Okay. All right. The court will set Ms. Newton for jury selection on the court's revolving, rotating jury selection docket. And so what that means, Mr. Crawford, is I'm going to set Miss Newton. She's not going to go to trial at the first setting, and she'll just go on the list and she'll work her way up. So, and she's going to have to come back each month until her case is reached for trial. So I'm going to set this for Monday, April 4th for jury selection. And Miss Newton, you'll appear at the courthouse here, but you'll appear down in the basement. Or actually, I'm sorry. I think they're no longer in the basement. They're there on the second floor, and my staff will be there to greet you, and we'll have additional paperwork for you on the next setting. And you'll continue to do that until your case is set for actual jury selection when you're actually going to trial. And Mr. Crawford's not going to be required to be here during those times, and he won't be until your case gets in the top 10 cases that could go to trial. Okay, so if you'll appear on April 4th about 8:30 or so, then Ms. Abraham or someone else will be down there. They'll have some paperwork, get you in, get you out. Okay.
Yes, sir.
All right, and the court will set all cases for trial on that date, and then as we get closer to that, then I'll need to know if there's going to be an election as to one case or the other that'll be going to trial. So we'll worry about that at a later date.
I think it's all a continuous.
Same transaction.
Yes, sir.
Okay. All right. If there's nothing further, then Ms. Newton, once you sign and get your yellow copy, you are free to go.
Yes, sir. Thank you.
May I be excused, Judge?
Yes. Thank you, Mr. Crawford.
Thank you.
All right, for the record, the court has had CR 21-346, State versus Cody D. White called. Mr. White was not present at 9 a.m. Beginning of court, he's not present now at this time, 11:35 a.m. Court has had his name called loudly and distinctly 3 times in the courthouse. Any response, Deputy Everett?
No response.
Court has also called Brittany Liddell Boyd, CR 21-280. She was set for plea today. She was not present at 9 a.m. She's not present at this time, 11:36 a.m. Court has had her name called loudly, distinctly 3 times in the courthouse. Was there any response?
No response.
There being no response to either Brittany Boyd or Cody White, court hereby issues judgment nisi alias capias. Court will set new bail in each matter. The court will reconsider its ruling if either appear before noon today. Court will stand in recess until the 1:30 jail docket. We're adjourned to this.